Lately, we have been hearing a lot about free trade agreements, in particular in the context of UK foreign trade policy after Brexit. One aspect of free trade deals that is left out from such discussions but remains hotly debated elsewhere is their roles on investment promotion and protection. Most of the new generation free trade agreements contain an investment chapter which has a number of important substantive and procedural guarantees that the contracting state parties agree to extend to each other's investors. What is the significance of these guarantees? In a nutshell, substantive investment protection guarantees are the rules which often go beyond what, for example, the law of the United Kingdom offers to foreign and home investors. For instance, international investment treaty rules entitle foreign investors to protection against state interference that may substantially diminish their profits. If a new law or regulation goes against expectations of a foreign investor by reducing the stability and predictability of legal environment or simply leading to a substantial reduction in profits, such investor can claim compensation by bringing a case directly against the host government. Guaranteed access to international arbitration, the so-called investor-state dispute settlement, means that a foreign investor can instigate its case against the government in front of an independent panel of arbitrators by sidestepping national courts of the host country. One example is a recent dispute initiated by a Swedish energy corporation against the government of Germany, challenging the German law on the phase-out of nuclear stations. Investment protection obligations are not a new phenomenon. The United Kingdom has been signing bilateral investment treaties since 1975 and now has in the region of 106 investment treaties in force. What is relatively new is the fact that investment protection commitments are increasingly being included in free trade agreements. Also, as far as future UK investment protection policy is concerned, another important factor in shaping future policy is the change in the direction of investment flows. In the past, the United Kingdom was primarily known as a capital exporting country, and even though investment treaties are reciprocal instruments, it was primarily British investors who benefited from investment protection rules when investing in developing countries abroad. Nowadays, however, the United Kingdom has become a recipient of foreign investment from fast-growing, emerging and developing economies. The most pertinent example is a Chinese investment into Hinkley nuclear power project. There are also talks of free trade agreements between the United Kingdom and the United States, Australia and Canada. Once such agreements come into being, and if they follow the recent drafting patterns by including investment protection obligations, the United Kingdom may also become a target of investor claims, challenging various governmental decisions and regulatory acts and demanding compensation where governmental intervention negatively affects the profits of corporations originating in those states.